You have been waiting for this moment for 6 years. 6 years of renewals, extensions, legal fees, and patience that most people could not sustain. You remember the exact day your attorney told you that your priority date was finally current. You remember calling your spouse, your parents, your children. You remember the feeling in your chest, that specific release of tension that comes when something you have worked toward for half a decade finally feels within reach. You open your laptop tonight to check the new visa bulletin. Your hands are steady because you have done this before. You know how to read the chart. You find your category. You find your country. And then you see the date. It has moved backward, not forward, backward. Your priority date, the date that was current last month and allowed you to file, is no longer current this month. You read it again. You refresh the page. You check the chart a second time, a third time. It says the same thing. The State Department has retrogressed your category. The window you were counting on has closed. And sitting in your living room tonight, in the silence after your family has gone to sleep, you are trying to understand how this happened and what it means for everything you have built. This is the moment that breaks people. Not the years of waiting, not the legal fees, not the paperwork. This moment. The moment when the visa bulletin moves in the wrong direction and takes your timeline with it. And what makes it worse is that most people who experience visa bulletin retrogression do not fully understand what caused it, whether it is permanent, what their legal options are in the window immediately after it happens, or what critical mistakes in the next 30 days could make their situation significantly worse. The confusion is not your fault. The Visa Bulletin is one of the most misunderstood documents in the entire United States immigration system, and the December Bulletin in particular has a history of delivering some of the most painful surprises of any month in the calendar year. If you are watching this after a retrogression has hit your category, or if you are watching because you want to understand how to protect yourself before it happens, you are in the right place. What I am going to tell you in the next 15 minutes is information that attorneys charge hundreds of dollars per hour to explain, and most of the people who needed it most will never hear it because they were watching the wrong channels and reading the wrong Facebook groups. Let me start by explaining the trap that catches 90% of people in this situation, because understanding the trap is the first step to escaping it. Most immigrants who have been waiting for a green card understand the visa bulletin in one simplified way. They understand it as a calendar. When the date in your category moves forward past your priority date, you can file. When it moves backward past your priority date, you cannot. That basic understanding is correct. But what most people do not understand is the difference between the two charts inside every single visa bulletin, and not knowing that difference has cost thousands of applicants months or even years of delay. Every monthly visa bulletin published by the Department of State contains two separate charts for each preference category. The first chart is called Dates for Filing. The second chart is called Final Action Dates. These are not the same chart. They do not contain the same dates. And which chart applies to you in any given month is not determined by the visa bulletin itself. It is determined by a separate monthly determination issued by USCIS, which announces whether it will accept filings based on the Dates for Filing chart or only based on the Final Action Dates chart. If you filed last month because the Dates for Filing chart showed your date as current, but this month, USCIS has announced it will only accept Final Action Dates, and the Final Action Dates chart shows your category as retrogressed, you may be in a different legal position than you realize. This is the trap. Two charts, two different standards, one monthly announcement from USCIS that determines which one controls your ability to file. And the people who do not know this difference are making filing decisions, travel decisions, and life decisions based on incomplete information. Here is why the December Bulletin specifically creates so much pain every year, and why 2024 and 2025 December Bulletins have been particularly severe for applicants from countries like India, China, Mexico, and the Philippines. The fiscal year for visa number allocation runs from October 1st through September 30. The State Department tracks how many immigrant visa numbers have been used in each preference category throughout the year. Toward the end of the fiscal year, if certain categories are moving faster than anticipated, the State Department advances the dates aggressively in the summer and early fall months to encourage people to file and use the available numbers. This is why you often see significant forward movement in July, August, and September bulletins. But when the new fiscal year begins in October, the allocation resets. And in the months that follow, particularly November and December, the State Department recalibrates based on demand projections, pending pipeline cases, and the actual number of new visa numbers available under the fresh annual cap. When that recalibration determines that too many people are in line relative to available numbers, retrogression happens. December retrogression is not random. It is structural. It is built into the way the system resets, and it hits the same oversubscribed categories in the same countries year after year, with a predictability that the system's designers seem unwilling or unable to address. Now let me tell you about the legal framework that actually protects you inside this system, because there is protection here, and most people never access it because they do not know it exists. If you filed your Form I-485 Adjustment of Status application during a month when your priority date was current under the applicable chart, and your application was accepted and received by USCIS, a subsequent retrogression in the visa bulletin does not automatically invalidate your pending application. Under 8 CFR 245.2, once USCIS has accepted an I-485 filing, the applicant's place in line is generally protected as of the filing date, not as of any subsequent bulletin date. This means that if you filed in October when your date was current and December retrogresses your category, your pending I-485 is not automatically rejected or returned. USCIS will hold your case until your priority date becomes current again under the final action dates chart before they complete adjudication. Your case stays alive. Your filing date stays protected. What this means in practice is that the most important thing you can do during a period of retrogression is ensure that your pending application is complete, that all your documents are current, and that you do not take any action that could jeopardize your pending status. The application you already filed is your anchor. Do not do anything that cuts that anchor loose. Now let me deal with what is being said on social media right now, because the amount of dangerous misinformation circulating about visa bulletin retrogression is genuinely alarming. I have seen posts in immigration groups telling people that when retrogression hits their category, they should immediately withdraw their I-485 and refile later when dates become current again. This advice is catastrophically wrong. Withdrawing a pending I-485 that was properly filed during a current period means you lose your filing date entirely. When you refile, your new filing date becomes your protected date, not your original one. For applicants from heavily backlogged countries, losing a filing date can mean going back years in the queue. Do not withdraw a properly filed and receipted I-485 because of retrogression. I have also seen content claiming that if your priority date retrogresses, USCIS will automatically reject your application and send it back, and that you need to refile immediately. This is also wrong. A properly accepted filing is not returned due to retrogression. USCIS holds it. There is a significant difference between an application that was accepted before retrogression and an application being submitted after retrogression. The first one is protected, the second one will be rejected. Understanding that difference is not optional. It is the difference between keeping your green card case alive and starting over. I have also seen notarios and immigration consultants, people who are not licensed attorneys, telling clients that they can pay extra fees to expedite their cases past the retrogression. This is false and potentially fraudulent. There is no legitimate USCIS process that allows an applicant to pay to move ahead of their priority date in a retrogressed category. The only legitimate expedite request process at USCIS is governed by the agency's official expedite criteria, which include severe financial loss, urgent humanitarian situations, and USCIS error, among other narrow grounds. Being frustrated by retrogression is not an expedite criterion. Do not pay anyone who tells you they can move your date for a fee. That money will be gone, and your case will be unchanged. My name is James. I am a senior immigration analyst with 6 years of experience, and on Immigration News Today, I do not give you opinions. I give you the survival strategies that keep families together. Let me now give you the exact action plan for protecting yourself through a period of visa bulletin retrogression, whether you have an application already pending or you are still waiting to file. The first thing you do tonight is go to the Department of State's travel.state.gov website and download the current month's visa bulletin as a PDF. Save it to your computer with the month and year in the file name. Then go to USCIS.gov and find the current month's announcement regarding which chart USCIS is accepting for I-485 filings. This announcement is published on the USCIS website under the Green Card section and is titled something like the agency's acceptance of the dates for filing or final action dates chart. Write down which chart USCIS is accepting this month. Write down your priority date. Write down the date shown for your preference category and country of chargeability in both charts. This is your baseline documentation for this month. You should be doing this every single month without exception. The second step is to verify that your currently pending I-485, if you have one, has an accurate and valid receipt notice on Form I-797. Your receipt notice contains your receipt number, your filing date, and your priority date as recorded by USCIS. Check all 3 pieces of information on that receipt notice and confirm they match your records. If there is any discrepancy, for example, if the priority date recorded on your receipt notice does not match the priority date on your approved I-140 petition, that discrepancy needs to be corrected through a service request on the USCIS online portal at my.uscis.gov. A discrepancy in your recorded priority date could cause your case to be held longer than necessary when dates become current again, because the system will be measuring your recorded date against the bulletin, not your actual date. The third step is to check the status of your case using the USCIS Case Status online tool at egov.uscis.gov using your receipt number. If your case shows a status of case is ready to be scheduled for an interview or any language indicating it is approaching the final stage, note that carefully. Cases that are interview-ready but sitting in retrogression are often among the first to move when dates advance, because the adjudication work has already been completed and the only remaining step is the final approval once the visa number becomes available. If your case is in this position, you want to make sure all your supporting documents are current and that nothing has expired while you have been waiting. The fourth step is to review the expiration dates on every document in your pending package. Medical examination results on Form I-693 are generally valid for 2 years from the date the civil surgeon signs the form, though USCIS may accept forms beyond that period in certain circumstances. If your medical exam is approaching or has passed its 2-year mark during a period of retrogression, speak with an immigration attorney about whether you need to update it before your case is ready for final action. Biometrics taken for your pending I-485 are generally considered indefinitely valid for the purposes of that application. But if USCIS issues a new biometrics appointment notice, attend it promptly and do not ignore it. The fifth step is to understand your travel options while your I-485 is pending in a retrogressed category. If you have an approved advance parole document based on your pending I-485, you may travel internationally and return to the United States on that advance parole. However, travel while your I-485 is pending is not without risk. If your advance parole expires while you are abroad, or if it is not honored at the port of entry for any reason, your pending I-485 may be considered abandoned. Before you travel internationally with a pending I-485, regardless of the visa bulletin situation, you must consult with a licensed immigration attorney. This is not optional advice. The consequences of an abandoned I-485 in a retrogressed category can set you back years. The sixth and final step is to set up a monthly tracking system for the visa bulletin so that you are never caught off guard by movement in either direction. The Department of State publishes each month's visa bulletin in the third week of the preceding month. The October bulletin, for example, is typically published in mid to late September. You should be checking travel.state.gov in the third week of every month for the upcoming bulletin release. When it is released, check your category, note the dates in both charts, and cross-reference with the USCIS announcement about which chart is being accepted that month. If there is significant forward movement in your category and your date becomes current under the applicable chart, you need to be ready to file quickly because forward movement can be followed by retrogression in the next month if demand is higher than projected. Visa bulletin management is not a once-a-year activity. It is a monthly discipline, and the people who do it consistently are the ones who are positioned to move when the window opens. I want to say one more thing before I close. If you are sitting with a retrogressed priority date right now, and you have been waiting for years, and tonight feels like a setback you cannot absorb, I understand that feeling. I have heard it from hundreds of people in this community. But retrogression is not the end of your case. It is a pause. The law that protects your pending application is real. The process that will eventually advance your date again is real. What you can control in this moment is your documentation, your tracking, your preparedness, and your decision not to make a panicked move based on wrong information from the wrong sources. Stay in your case. Stay informed. And do not let anyone tell you that a retrogression means you need to start over, because in most situations, it simply does not. Immigration rules change overnight. One executive order, one court ruling, and everything shifts. I send urgent alerts to my WhatsApp community before I even post on YouTube. The link is in the description and pinned comment. Join now. It is free, and it could save your case. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration News Today right now and turn on notifications. Staying informed is no longer optional. It is essential. I am James. Protect your status. Protect your family. I will see you in the next update.